Thank you so much, Patricia, and welcome everybody. Thank you for joining us for today's webinar, which is part 2 of addressing court-related barriers to survivors' economic security. My name is Yvette Butler, and I am the Director of Capacity Building and Systems Change for the Center for Survivor Agency and Justice. And I'm joined by my colleagues, Erica Sussman, the Founder and Executive Director, and Sarah Wee, the Director of Research and Programs, and our several faculty who I will introduce in a moment. So this part 1 was about the economic barriers that survivors often face, and then this webinar is about building multi-level strategies and how we should address those barriers. And of course, in the chat box, please feel free to introduce yourselves, tell us who you are, where you're from. Feel free to ask questions, throw out comments all throughout this webinar. So, a couple of housekeeping issues. This webinar is recording and will be available on our website in a couple of weeks. There is a files box in the sort of bottom right-hand corner of your screen, which includes a variety of resources, including the guidebook chapter on court barriers and 3 different worksheets. And we will go over how those worksheets work later on in this webinar. And of course, engage with us, whether that's here in the chat box, tweeting at us, emailing us, hitting us up on Facebook. We love to hear from you all. So the Center for Survivor Agency and Justice promotes advocacy approaches that remove systemic barriers, enhance organizational responses, and improve professional practices to meet the self-defined needs of domestic and sexual violence survivors. And our vision is that we will have a world where all people have equal access to physical safety, economic security, and human dignity. So now, to briefly introduce our faculty, we have Nida, Abbasi, and Jenna Smith from the Center for Court Innovation, Wendy Vaughan, Associate Professor at Northern Illinois University College of Law and the Supervising Attorney for Zeke Georgie Legal Clinic, and Katie Bondolindi, who is one of CSAJ's expert advisors and an adjunct faculty member at Washington University Brown School of Social Work. So this is one of our more interactive webinars. So after CCI tells us all about specialized DV court responses to barriers to for survivors, then we will enter breakout groups. Everybody will be sort of randomly sorted into breakout groups where we'll talk about needs assessment, partnership building, and strategies for systemic change. And then at the end, we'll all come back together and debrief on what we talked about and key takeaways and action items that hopefully people can use in their own jurisdiction. So I'm happy to now turn it over to the Center for Court Innovation.
Hi everyone, this is Nida Abbasi. I, like you had said, am the manager of the Gender and Family Justice team at the center. We do a lot of technical assistance and training with courts and communities across the country to help them enhance their responses to domestic violence. And before that, I was a civil legal aid attorney for clients on their order of protection and family law cases in Chicago. And I'm really excited to join you all today.
And I'm Jenna Smith. I'm the project coordinator for the Gender and Family Justice team here at the center. I've worked here since 2015 around a lot of our court training and technical assistance initiatives. So we'll be sharing our contact information at the end of the webinar, but feel free to check out our website and some of the resources we have available online. So what we're hoping to achieve today, for those of you who were able to join part one, we got a really great conversation going and heard some great tips and strategies from you all, and we're hoping to take a little bit of a deeper dive today. We'll be kicking it off just by going over a little bit about specialized domestic violence court responses and ways in which that those can help address economic barriers for survivors. You'll get to hear from Wendy about some of the work that she's done through the Winnebago County Domestic Violence Mentor Court in Illinois. And then we'll go into those breakouts and hopefully get some further discussion about what you all are doing and come up with some additional strategies. And I'm seeing that most of you have already started typing in, introducing yourself. Thanks so much for that. If you haven't yet, please definitely share who you are, what you do, and where you're located. But it looks like we have a really great mix. I'm seeing some attorneys, some advocates from all over the country, so that is awesome. Thanks so much for joining. Just a little bit about who the Center for Court Innovation is. So we're a nonprofit. We're based in New York City, and we do a lot of different initiatives around justice system reform. And we have three approaches to that work. So we're looking at research and evidence-based best practices. That's one arm of our organization. And then we also run a number of what we call demonstration or operating projects. Our lot are based locally here in New York City. We have some statewide in New York State and some in New Jersey as well. And we look at those as kind of an opportunity to pilot and test new and innovative approaches to a variety of issues confronting the justice system. And then our third arm, which is the majority of the work that Nida and I do for the Gender and Family Justice team, is within our expert assistance department, which you may know as technical assistance. So we're funded through the Office on Violence Against Women to support courts and communities across the country working on issues around things like domestic violence, sexual assault, dating violence, and stalking. And we take a lot of those lessons learned at the local level, and we look to share them nationally between courts, between communities and judges, so that those of you who are tackling these issues aren't having to reinvent the wheel and can learn from your peers from across the country. So just a little background about specialized court responses. I'm sure many of you are familiar with them and probably have some in your communities. A lot of places have implemented things like drug courts or mental health court models, but we do like to set off these conversations by distinguishing between what we call problem-solving court approach and an accountability court approach. The main difference being that in something like a domestic violence court, you're focusing a lot more on the party who's a victim in the case, so making sure that victims have access to services, to advocates, that the folks that are in the courtroom handling these cases are trained on the power dynamics within domestic violence issues, and that there are real protocols and safety measures in place to address those. So for those of you who are familiar with something like a drug court, it's a very different tone that the courtroom and the judge are setting, the focus being on offender accountability, making sure that the justice system is taking these crimes seriously. it is more challenging in some respects because with something like substance abuse, you may be able to run a urine analysis or be able to tell if someone is complying with court orders. But with domestic violence cases, as we all know, it's much harder to measure whether the terms of orders are being complied with. So having that awareness within the courtroom and with all the stakeholders involved is a primary difference when we're talking about DV courts. So these are some of the components of specialized DV courts. You have a dedicated docket just handling DV cases. There's usually a designated judge or sometimes judges that have special training around domestic violence dynamics. Oftentimes the entire court staff, so attorneys and court officers and others within the courtroom are dedicated to that court. There are additional safety measures like I talked about, so there may be safe waiting spaces for victims, making sure that the parties are separated before and after their cases are called, and then providing that really critical link to advocates. In terms of accountability measures, the courts focus a lot on compliance and having regular compliance calendars that call the abusive partner back, checking in to see if they're complying with the terms of the order. So are they going to batter intervention classes, and having the judge provide that level of oversight and monitoring to show that the justice system is involved in making sure that the abusive partner is compliant. The other big piece is also helping the judge make informed decisions, so giving them access to information around risk and lethality, having them get reports from things like that, or intervention program classes, from probation, from visitation centers, so that when they're making their decisions around the case, they have access to a lot of the information and really understand what's happening within the family. There's usually, some courts are set up with one judge, but for those that aren't, there's access to info on both the civil and the criminal side to avoid situation in which there's conflicting petitions. And so, again, the judge is just very informed about what's happening with the family. Training is a really big piece, and so regular ongoing training for staff whenever there's turnover, and also ongoing meetings to make sure that all the stakeholders are present at the table. These are typically convened by the judge, and are an opportunity to share and identify gaps within the system and kind of address those as they come up. It's not a one-size-fits-all approach, so a lot of communities may start with just a dedicated docket and then over time add a lot of additional resources to help enhance their response, and it may just depend on what resources are available in your community, but there's a lot of different models out there, which we'll talk about in a little bit. And again, so these are just some of the elements, and a lot of, you'll hear a little bit about our domestic violence mentor courts, but a lot of these core competencies make up what they do. And again, there's just a real emphasis on training, particularly on domestic violence dynamics, having that coordination with one judge or multiple judges, and providing referrals and linkages to advocates and legal representation.
So there are over 300 domestic violence courts in the United States that are distributed across 27 states. And there are also over 50 DV courts across the world. And it's important to remember that there, like Jenna was saying, there's no one way to run a domestic violence court. Some have all the elements she just discussed on the last slide. Some have a combination of a few, and a lot are still working on improving their overall practice. Many domestic violence courts start off with implementing one or two elements that are feasible, and while others try to implement the entire system at once. We do get a lot of requests from sites who are interested in just starting a whole domestic violence court, and so they're thinking of putting in several of those components at the same time. But you're all experts in your own communities and have a good idea of what would work best. It's also important to remember that having a domestic violence court doesn't automatically mean that survivors are going to be safer and abusive partners will be held accountable. You have to have a dedicated court staff and judges to collaborate with the community to respond effectively to the needs of litigants in these cases, because like Jenna was saying, they are incredibly complex and no one case is going to be exactly like the other. And one thing to note is that these figures do mean that there are still many, many jurisdictions that don't have specialized domestic violence dockets or courts, and their judges may not have received any specialized training in domestic violence. So even if a domestic violence court isn't perfect, just having that foundation in place helps raise awareness on different issues that come up around domestic violence, like economic justice. So these are the critical principles of DV courts that differentiate them from other types of courts that process domestic violence cases. One of the major components is having an engaged judiciary. So it could be like the one family, one judge structure, or having just a judicial champion that ensures all the judges and court staff are receiving ongoing training on domestic violence dynamics and the related issues and paying attention to whatever gaps and challenges are coming up in the community. Also, coordination between courts as well as stakeholders. We often talk about having a coordinated community response to domestic violence, having regular meetings between the court and other community stakeholders that work on domestic violence cases helps to make sure that everyone is aware of whatever challenges are going on, and that ensures that they can coordinate and work together to improve those gaps. Also, improved victim safety for both petitioners and children. Domestic violence courts implement a lot of different measures to enhance victim safety, whether it's a comprehensive referral process, having in-house victim services and advocate staffed in the courthouse, compliance reviews, and there's a lot of other things that they do. Identifying offender risks and needs. So risk assessment is a big issue that comes up again and again in a lot of jurisdictions, and there's a lot of different ways to go about gathering information about risk. It's important to, if you're thinking of doing some type of risk assessment, to get as much information on that as possible, because it is a really complicated area, and you want to make sure you're doing it as safely as possible, and not everyone is in a role to be able to gather that information and process it. Improved information sharing between agencies where it's appropriate. And finally, assessment and research, again, looking at what's working and what isn't, and that is something that can be accomplished through litigant satisfaction surveys or data collection and a few other measures. So there are different ways to structure a domestic violence court. Based on the ones we've seen across the country, it can be a fully criminal domestic violence court where they're processing felony and or misdemeanor DV cases. It could be fully civil. They could just be focused on orders of protection or orders of protection plus family law matters. It can be an integrated or coordinated model where they join the civil and criminal matters together when they're related to the same parties. And finally, there's juvenile DV courts that center mostly around teen dating, and which brings up its own special issues, and they might be aimed more towards rehabilitation. So this is a closer look at how integrated or coordinated models are structured. So that's when the court is trying to combine the criminal and civil cases. So in New York State, we have the IDD, or the Integrated Domestic Violence Court models, and they combine a family law case and the criminal case that are related to the same parties into one and present it before one judge. And the idea behind that is having one judge per family prevents information from being lost between the civil and criminal case, and one judge is familiar with what's been going on in the history of violence and can make the most informed decisions. And then there's other courts across the country who have a coordinated DV court model, including Winnebago County, which you'll hear about shortly, and that has generally separate judges for the civil and criminal cases, but they have a resource coordinator or some form of information sharing to make sure that both of those judges know what's going on in the other case. So we work with mentor courts across the country. The Office on Violence Against Women has designated domestic violence mentor courts that have been leading different strategies to respond to DV across the country and have implemented promising practices in their court's response to DV. And so the first crop of DV mentor courts came up in 2013, and you can see that they're spread out across the country in Idaho, in Minnesota, in Illinois, again, Winnebago, in New York, and in DeKalb, which is in Georgia. And then in 2017, they added more, also spread across the country. I think OVW is trying to make sure they hit a lot of different geographic regions because, of course, different areas have different needs when it comes to domestic violence, and they wanted to make sure that they're representative. And these courts, like I was saying before, have different ways of combining either civil cases or criminal cases, or doing them both, or they might be focused on felonies or misdemeanors or one thing or the other. So you can see that there's a lot of different types of models out there, and they can all be leaders in whatever strategies that they're implementing. And then these are some of the things that mentor courts are doing. So they have different ways of sharing information between courts and agencies, ensuring compliance for abusive partners, performing risk assessment on abusive partners and survivors, also responding to the needs of the underserved communities in their region, ensuring that there's cross-agency collaboration, and finally offering different types of victim and offender services. And these are some ways that the courts directly address economic barriers. So they could be linking survivors to advocates who can inform them of their rights and provide different types of support throughout the legal process. They can be providing basic legal information for self-represented litigants, and we know that up to 80% of litigants on DV cases do not have an attorney, so just getting any type of information about the process is super helpful to them. They might also offer pro bono representation if legal aid isn't covering everyone who is on a DV case and can't afford an attorney. Financial relief on temporary and permanent orders of protection, coordination across courts, which we talked about, ensuring that there's fewer in-person appearances so litigants don't have to keep taking time off of work and coming to court, co-location of services so litigants don't have to go from one area to the other and spend more time trying to get the services that they need. And finally, ensuring that litigants have access to child care so that they don't have to pay for that while they're in court and can actually come to court for their orders. And I wanted to turn it over to Wendy, who's going to talk a little bit about their court model in Winnebago.
Hi, everyone. My name's Wendy Vaughan. I am really at heart a legal aid lawyer. I've been a legal aid lawyer for the last 22 years. I also teach at a law school. Winnebago County is in northern Illinois. It is a place of about 250,000 people. We have a very urban core with a city of around 150,000 folks, as well as some very rural areas. So we have a lot of challenges. One great thing about our community is that there's been a long history and tradition of collaboration. And with the groundwork laid after really decades of cross-training and work among different agencies, we decided in 2012 to do a great overhaul of our court system and created what Nida was explaining as a domestic violence coordinated court. And in our court system, we have a dedicated criminal court that hears misdemeanors, felonies, and orders of protection, as well as a dedicated civil court that hears primarily family law cases and orders of protection. Because we have so much domestic violence in our community, we've actually had to add an additional judge to the civil side of our court to handle the volume of cases that we're seeing. But our overreaching goal is informed judicial decision-making, survivor safety, and accountability. So we are combining the model of an accountability court along with specialized DV courts in both the civil and criminal process. We've known for many years, and it was really highlighted, I think, when we created this model, that many survivors coming to our court system are without counsel, and that those survivors trying to navigate the court system was very, very difficult. Our dedicated judges who had received specialized training and who were more attentive to what was happening noticed that survivors frequently just dropped out of the case entirely and stopped coming to court, particularly when the other party was represented by counsel. That oftentimes survivors would agree to arrangements that may not be the safest for them just to end the case quickly, or because they felt a power imbalance, right, with the counsel representing the other side. Sometimes survivors would go to trial on their own and would shut down in the middle of a trial. They would not be able to present the evidence that they had, felt overwhelmed by cross-examination, and really were at a disadvantage, particularly when the other side had counsel. And so we decided that we wanted to try to address that, and we've done that in two different ways. One in our dedicated criminal court, and the other in our dedicated civil court. So I'm just going to talk with you about what it is that we did. In Illinois, our domestic violence statute, and now our criminal statute, allows our state's attorneys, which are the prosecutors in Illinois, to actually get protective orders in conjunction with a criminal case. In our community, our state's attorney's office had really stretched to the point of full capacity, and were unable to dedicate resources to doing this previously. And so even though there was a remedy in the law allowing protective orders in conjunction with a criminal case, it wasn't being done. So our first solution was to find a way to help the state's attorney utilize this mechanism. We were concerned and wanted to make sure that any protective orders coming out of the criminal court were just as great as those coming out of the civil court, and that survivors in the criminal court system getting their order of protection in the criminal courtroom would get the same kinds of remedies as other survivors in other courtrooms. And so to do that, we were able to get some grant funding and to hire some victim service providers to work with survivors in this context. These survivors are working with victim service providers who are not protected in the same way as victim advocates are, so those are some challenges that we still face. Survivors have the option in our court system to bring a protective order along with the criminal case or not. No survivors are ever required to work with the state's attorney's office if that's not something that they're comfortable doing, and they're not forced to do that. The great thing about it for those survivors who choose to go that route is that the state's attorney is actually there to present the case for them. The victim service providers will help their survivors do the paperwork, and the prosecutors are in the courtroom. What we have found is that the vast majority of criminal defendants who are also respondents in these order of protection proceedings will just agree to the entry of the order of protection. So it is a really great way to level the playing field for survivors who have companion criminal cases. We still have a lot of survivors, though, who may not choose to engage with the criminal system. Maybe they don't have a criminal case, or even if they do, they don't want to cooperate with the prosecution for a variety of safety reasons or other reasons. And so we also want to make sure that we could level the playing field in the same way in our dedicated civil courtroom. In our community, although we have many lawyers, we have found it very difficult to recruit pro bono attorneys to help many of our survivors. Pro bono attorneys would tell us that they were concerned that once they entered into a case, that they would be on the hook for future family law matters, for future financial matters, and really weren't willing to commit in a large way. What we decided to do was to try and match pro bono attorneys specifically for cases where the other side had counsel. So the way it works in our community is that when a survivor comes to court on the first return date, which is typically a trial date, and is there hopefully with an advocate, which we have in all of our courtrooms, and sees that the opposing party is there with counsel, that survivor can request a continuance in order to get counsel herself. She may be getting counsel privately, she might be getting counsel from our clinic or our local legal aid provider, but she may be able to get counsel through what we're calling our pro bono attorney project. And so our law school, along with Prairie State Legal Services, has trained a cohort of lawyers who are willing to step in to the order of protection case only. Through our Illinois Supreme Court rules, we're able to limit the scope of their representation to just the entry of the plenary order of protection. So once this continuance is granted by the judge, our local legal aid provider tries to match up a pro bono attorney with the survivor. That attorney will then come to court for what we call here a status hearing. The survivor doesn't necessarily need to be at that next court date. The sole purpose of that court date is to either enter an agreement or to pick a trial date that's convenient for both counsel and their clients. And in that way, we can expedite the order of protection process, and we can make sure that any court dates that are set are days when our pro bono attorneys are actually going to be available, and it will work with their own schedules, which was another barrier that we found when trying to find pro bono counsel to take these cases. Part of the work of the pro bono attorney project is to recruit lawyers from the community, and also to really do ongoing training with these attorneys. Many of the attorneys that are volunteering are very experienced family law attorneys who are getting free CLE and also maybe retooling some of their own skills and hopefully changing even some of their perceptions or misperceptions about how domestic violence works in families and the impact that trauma has on their clients and on the children in the case. So we found that to be a benefit. We also recruit relatively new attorneys and try to partner them with more senior attorneys who can mentor them and help them. By having our law school clinic as a partner in this project, we're also able to take on any overflow cases if there's just too many and not enough pro bono attorneys to go around, or if our legal aid provider agency has some kind of conflict. And it has worked extremely well. We have found that with the benefit of counsel, our survivors are more likely to stay with the case. We're having fewer cases dismissed, that survivors are able to present their evidence, and also the court has a much more robust and better understanding of what is actually happening in the family. Because we have the specialized domestic violence courtroom, the civil court judge who hears the order of protection case is likely going to be making decisions related to child custody and support issues in a subsequent family law case or divorce. And so having an attorney there to present that information at the early order of protection stage on behalf of the survivor really makes it possible for the survivor's story to be told in a way that the court can understand and appreciate and to take into account as the court moves forward. We've learned from this that we still have barriers to the court. We know that many survivors have the same challenges and barriers when faced with their abuser in a courtroom, whether that abuser has an attorney or not. Our goal is to be able to provide a pro bono attorney or free legal services to all the survivors in our community that need us. Our survivors also tell us that while it is wonderful to have a pro bono attorney at the order of protection phase, that they really need ongoing legal services for those ongoing family law issues that arise. And we know, as folks who work with survivors, that oftentimes abusers manipulate the court system and really wear our survivors down. So our goal is to recruit as many pro bono attorneys as possible. By partnering with a law school, we're able to educate young lawyers about the need for these kinds of services. We're able to work with our local bar association as young lawyers are coming into our community and joining the bar association to do training with them and invite them to get involved. And it just remains a barrier. I don't know how we can solve the critical need for legal services in our community without more funding and more resources, but it's certainly something that we are continuing to work on in Winnebago County. I can say, though, that in 2012, when we embarked on this project and did the overhaul of our court system, it was met with a fair amount of skepticism and resistance by others in our community who may not have been as on board with this approach. But I think over time, everyone in the legal system, at least, coming in the courthouse, and certainly our survivors, tell us that having the specialized courts and holding their abusers accountable has, in fact, been successful. And so as we continue to whittle away at these economic barriers, and as we find more barriers in time as we go along, it certainly has proven to be a very successful endeavor for us. As a mentor court, we're also welcome to talk to you guys whenever you might need us. I'm part of the mentor court team and can talk with you later about what challenges we faced and how we've solved those in Winnebago County if you'd like to do that in the future. And so I think that is it for my part of the presentation.
Great. Thank you so much, Wendy. Let's see. So does anybody have any questions for Wendy before we move on to the breakout rooms? That was a lot of really great information.
This is Sarah. While folks are typing in, one question I had just based on some of the work we've done with communities across the country is, and what really resonated, Wendy, from what you were talking about, is how you use a lot of different resources. So pro bono attorneys, partnering with law schools, there kind of seems to be a spectrum of different levels and flavors of partnership. And I'm wondering if, I know you said you're also urban, but you have some rural areas in your county. For rural folks that we work with, you know, the limited availability of even pro bono attorneys makes some of this hard. I wonder if you could speak to that a little bit, or if anything has worked really well for you in gathering these different kinds of partners in your community?
Sure. I think for us, it's really relationship building over time. We bring folks together at least once a month for meetings. We try to have social events and food and other things that help folks get to know each other. We really invite a wide spectrum of questions from our community. When we embarked upon creating the specialized court, we met with public defenders, we met with the private criminal defense bar, we talked to prosecutors, we talked to family law attorneys, we of course talked to advocates and survivors, folks dealing primarily with children, with sexual assault survivors, domestic violence survivors. So I think communication is really the key, and bringing people in and inviting their feedback. And sometimes their feedback is difficult and critical, and being open to that and trying to work through that with them over time proves to be successful. We've also just really reached out over and over again. And so if folks haven't had time to connect with our court in the past, we reach back out. And so it's never too late to get started, and it's never too late to recruit more partners. There's not enough people in our community to do all the work that we have to do. And so we have to leverage all the resources that we have and engage people in ways that helps them understand that the work we're doing with survivors and their children to provide safety and to reduce trauma impacts all of us. And so that's really been just a theme and a message that we've tried to get out there. So I'm just looking here. It looks like we have a question from someone who says they have 2 pro bono attorneys that take almost any victim case and advocate. So that's wonderful that you have that ability. And so I think one of the challenges for rural communities, and certainly our law school is in a more rural area, many of our young lawyers go out to rural communities. There's really a crisis in rural America with not enough young lawyers able to afford to go and practice in rural areas. So there's a dearth of lawyers in general, and those lawyers that are in rural areas are often very burdened and may not have as much time to devote to pro bono services because there's such a high demand for their services anyway. So that's an ongoing challenge.
So Wendy, you mentioned something about, you know, like the issue with pro bonos and I guess like the process to getting them to be able to, in essence, do like limited scope representation, it sounded like. So just doing the CPO cases so they wouldn't have to worry about, you know, I suppose in the words that you use, like being on the hook for further representation. Did you have to change any court rules for that to happen, or were you able to work within the rules as they were?
We were able to work within the rules as they are. So the Illinois Supreme Court allows limited scope representation and also allows lawyers to use certain Illinois Supreme Court forms to notify the court and parties about the nature of their limited scope representation. However, in Winnebago County, until our clinics started using limited scope representation in some cases, no one in our county was actually utilizing those forms, had never seen those forms, and the lawyers were extremely resistant to the notion of limited scope. So we had many trainings and provided ethics, CLE, professionalism credit just to educate lawyers in our community about what is limited scope representation and is it okay to do it, and what are some of the benefits, what are some of the risks, and when is it appropriate, because it's not always appropriate for every client. So while we had an infrastructure in place, it was underutilized, I would say, and very, very much misunderstood. It looks like we also have a question for somebody asking about how do we center the economic needs of survivors in legal representation. So in our Illinois law, we have a lot of remedies that are economic remedies for survivors related to not only housing, personal property, spousal maintenance, child support, economic damages, and we've really tried hard to educate not only our prosecutors, who are very unfamiliar with civil remedies, but also our pro bono attorneys about those remedies, the type of evidence they need to put on to get those remedies. So we are able to address many short-term, at least, economic needs of our clients through the order of protection process by pleading facts that allow those remedies to be awarded and by putting on evidence to get those remedies.
That is really helpful, and I appreciate you talking about that. And one of the questions that we often get in the context of pushing for economic justice in civil cases is really a question about how best to shift the culture of courts, because we know that many courts across the country are often just not inclined to include economics within their vision of safety, which is essentially what we're trying to do, right? Expand people's vision of what safety requires. So I'd be curious to hear a little bit about like how that has happened, right? Because part of it is about zealous advocacy, and then what other things might you uplift to kind of shed some light on how judicial officers have shifted and expanded their thinking?
I think the key for us has really been judicial training. I think you've really highlighted that issue. We needed to have our judges understand that in order for a survivor to stay safe, economics were going to be key to her safety plan, and that it's not helpful to have the same survivor coming back to court 3, 4, 5, 6 times because we weren't able to meet their economic needs and provide a plan that was realistic and practical for them. So it does take more time. These cases take longer because more information has to be provided to the court. The court has to deliberate on more issues. And so we've been able to shift the culture by explaining to judges and training judges, and they've seen it themselves, that by investing that time up front, by trying to get it as right as possible up front, that survivors have a better possibility of remaining safe and not returning to their abuser. That may not always be the case, but that it's our job to make it as possible for them to stay safe as we can. So educating judges and really shifting the docket so that there are fewer cases on the docket so that we can get to those economic issues and have time carved out in the day to do that. That has been really a huge part of it.
Thank you so much, Wendy and Jenna and Nida, for all the great information. And we want to give you a little bit more time now. We're going to break up into 3 different workrooms. And in each workroom, one of you will be with one of the experts that we just heard from. So we are going to have 3 different rooms that we have some time to have some more questions and answers with the faculty that we've already been with. You will just be placed in a room. When we break out, you will all of a sudden see yourself placed in a specific room. When you get to that room, you will have the opportunity to answer a question that will be posed to you regarding the topic that we're going to be diving into deeper in that room. We are going to have a needs assessment room that will be really focusing on what are some of the court barriers that you are seeing in your own community and thinking about what you need to do in terms of meeting those needs. What are you already doing? And it will give you the opportunity to talk with Jenna about some of those needs and how CCI has helped different communities look at those needs. Some of you will also be in the partner mapping room, and this room will give you the opportunity to really think about who are some of your partners that you're currently working with to deal with some of the barriers that survivors are facing based on their economic needs and the court needs. Who are some partners that you're currently working with, and who are some partners that you potentially could think about partnering with that you haven't yet already? And in this room, Nida from CCI will also be there to help think about some of the partners and the partnership work that has been done around the country within these specialized courts programs. And then the final group will be looking at strategic action and planning, which will really look at what are some of the action plans that will need to move forward in terms of creating system change within your own community, in terms of what the court is offering, how we can start working on minimizing or strategizing around the barriers that survivors are facing with some of the court issues. And Wendy, who has just been sharing the experiences in the Winnebago County, will be in that room with you all having those conversations. So I will now pass it over to our webinar hosts, who will place us all into different spaces. You can engage in the conversations. You will not be able to be heard to ask questions auditorily, but you are encouraged to chat in that room, to ask questions of the experts, to share information that you have in your specific room. So we will all convene back here in 15 minutes and do some follow-up and hear from everybody what happened in their different workrooms. So thank you.
Hello, I think we're back.
Okay, great. Thanks so much, everybody. So we wanted to do a group debrief. So let's start with some key takeaways from the needs assessment room.
Great. So this is Jenna. I was in that room with Sarah, and Sarah, I may be looking to you to help fill some of this in.
Sure.
You know, we talked a little bit about, we started off with our poll questions and kind of hearing from folks about whether or not they already have a process in place for addressing court-related barriers. And interestingly enough, about over 50, almost 60% did. So they shared a little bit about what those processes look like. We talked a lot about meetings and the advantages of having the court convene those and for the judge to be a part of those meetings. A lot of folks shared the ways in which they partner to provide pro bono services to survivors on cases. And we talked about how to effectively train court and judicial stakeholders. So CCI has developed a training needs assessment tool so that you can solicit information from those partners about what trainings they've already received, what areas they identify as a need, and help develop it with them jointly, and how that can help get buy-in into the process and get the court to attend those meetings and really gain the most out of it.
Yeah, I don't really have much to add other than that link between using training to support needs assessment and also using partnerships. There's sort of a symbiotic relationship between those things and how they can all work together. The other thing that came up is just sort of an emerging need that we probably all collectively can think about, and how to address this is just the issue of simple things like court documents, copies, filing fees, all these things that seem fairly little and can have really big, huge consequences for survivors. So there's a need to kind of think through that and maybe do some needs assessment to find some creative solutions to some of those barriers. but I appreciated the link between a bunch of levels. And thanks for folks hanging in there with some of the audio. I know that wasn't just in our group, but I think that's it for needs.
Okay, great. How about the partnerships room?
Hi, this is Nida. We talked about just getting started on partnership mapping and how that process would go, what it would look like, how you can identify different people you wouldn't normally think about in terms of partners, and how that might be helpful to your overall coordinated community response. And we also talked about some problem solving around getting judges on board, especially when they're resistant, which is something we hear about a lot in our work with different communities, and it is definitely a long-term process. And then also some issues around economic barriers for survivors who are trying to do cases other than orders of protection, and some of the fees that they might face, and thinking around how you could potentially work with your local court administrator to think about ways to get those fees waived.
Great.
Yeah. The only thing I would add is we also talked about judicial training and kind of how maybe you might use some of your partners in doing some of that work together. And I heard Nida say a number of times, really focusing on this idea of creating some sort of a work group to come up with some joint work together within the community.
Okay, excellent. Thanks so much. So from the systems room, we talked a lot about things like transportation, childcare, and employment. And so, of course, with transportation, especially in rural areas, there's a question of, just how does somebody get from point A to point B, or like get to all of the services that they need. If there's, say like no public transportation, no Uber or Lyft. And so one of the things that came up was about a family justice center. So at least there's a central location for survivors to go to. For childcare, just a similar thought of, if the courthouse or wherever they're going has childcare, that's always beneficial. And on the employment front, something that I thought was really interesting that Wendy told us about was their efforts to do remote calling or like remote CPOs. And so it'd be nice I know it would save folks a lot of time in travel and just like wasted time sitting in court if they could do hearings remotely. Wendy, do you have anything to add to that?
No, I would just say that overall what was really great is that in the poll we learned that 100% of the folks in our breakouts already doing some kind of system advocacy. 81% of them were regularly sharing information, 75% of them were collecting data, and almost 70% of them were doing some kind of policy work or legislative advocacy. And so I think that's really encouraging that people are already doing this work and thinking about system change. So I would just add that.
Yeah, great. Thanks for adding that. And I think just like one thing to throw out to the group, I know we're running low on time, so maybe this is just like maybe if it can be answered really quickly or in the chat box, is who can you partner with on issues like transportation? So I don't know if like the partnership group got into like uncommon or like unlikely allies for that issue, but I didn't want to throw it out there as like a big question mark. So yeah, let's just say if anybody has ideas on that, please throw it into the chat. And Sarah, did you want to give an overview of the worksheets that are available for download?
Sure. While folks are thinking about Yvette's question, I love that question about transportation and generally the unlikely allies in the work. Partnership seems to be running a thread through all of this. To kind of carry on the work that you are doing in these groups, we have a couple of worksheets that alluded to, 3 of them actually. One on needs assessment. It walks you through a process of asking some of the questions you see here. What do you know about court-related barriers to survivors' economic security? How did you come to know that? And what else do you need to know? Walking all the way through to identifying gaps and using that to then identify some goals. And these can be done in a self-reflective way, or as some of the groups we're talking about really brought to some of your collaborative groups to think through some of these issues in greater detail and gather multiple perspectives. So that's what the needs assessment worksheet walks through. In the partnership building, we really kind of take a almost a safety planning approach to this, so thinking about what works, what you know, what are strengths of partnerships, where do you think they're coming from, what do they value about you, mapping your relationship with them. Are you formal and talking together all the time, or are they someone maybe on an outer ring of your network that, as Yvette was saying, might be an unlikely or unexpected ally, and just thinking through how you can really articulate who they are and think about how you might engage them in your work. And then finally, some joint thinking both in strategic planning and how do you translate all of this into action, which is so critical, and make sure that that action actually attends to the economic realities and lives that we've been talking about in these webinar series. And that's also paired with the second page of this worksheet to break down some policy or systems that you know about so that we can make sure that we have a really sound understanding of how policies and systems are having an impact in survivors' lives and can use that to hold systems accountable where we need to. So you will find these worksheets in the file pod right here, so I invite you to download them. We'll also share them with you in follow-up and try to include some of the notes and conversations that happened today in those worksheets as a little starter kit for you in these conversations. So we hope that's a helpful action step that you think about taking back to your organizations and different partnerships as you walk away today. I think that's it, and we have some time for some final questions and some resources. So I'll throw it back to Yvette and really all of our faculty.
Thanks, Sarah. Do any faculty have any final thoughts? And if anybody has any final questions, comments, please throw it into the chat box.
This is Jenna. I would just encourage everyone to definitely, if you have follow-up or questions, definitely reach out to us. We're happy to answer any other questions you have, and there are some additional resources that we have on our website that may be of interest. And if a specialized DV court response is something that you think could be a valuable asset in your community, we have a whole toolkit that if you email us, we can absolutely share.
Great. Anyone else? This was great. So thank you, everybody. All right. Well, it sounds like that might be it. So thanks for joining us. Don't forget to download the files, PowerPoint, the mapping worksheets in the file pod right there, and be on the lookout for a follow-up email from us with certificates of attendance and like the webinar when it's posted on our website.